The Department of Justice just admitted they've been violating your constitutional rights for 90 years, not in some quiet memo, not in an internal policy shift, in open court, in writing, a full confession that the federal government has been pricing poor Americans out of the Second Amendment since 1934, and they can't defend it anymore. This is the story of how one instructor from Arizona just took down a piece of the National Firearms Act, and why what comes next could dismantle the entire framework of federal gun control as we know it. If you care about constitutional rights, about government accountability, about whether laws apply equally to rich and poor Americans, you need to understand what just happened, and you need to hit that subscribe button right now, because the mainstream media isn't touching this story with the depth it deserves, and what unfolds over the next 12 months will redefine firearms law in America. Let's get into it. January 20th, 2026. While most of America was focused on other headlines, Acting Associate Attorney General Benjamin Williams walked into a federal courthouse and filed a 47-page document that should have made front-page news everywhere. It's called a confession of error. It's what the government files when they admit they were wrong. Not kind of wrong, not technically wrong on a procedural detail. Fundamentally, constitutionally, catastrophically wrong. This wasn't about one case in one jurisdiction. This was DOJ attorneys filing notices in 6 different federal circuit courts simultaneously, from Arizona to Maine, systematically withdrawing their opposition to suppressor challenges that had been grinding through litigation for 3 years. Cases where they'd spent hundreds of thousands in taxpayer dollars defending the National Firearms Act. Cases where government lawyers wrote 156-page briefs in September 2025 explaining why suppressor regulations were perfectly constitutional. 5 months later, those same attorneys filed documents dismantling every single argument they'd previously made. Let that sink in for a second. The same lawyers, the same cases, the complete opposite position. What changed? Not the facts, not the law on the books. What changed was the legal standard the courts now apply and the government's realization that they couldn't win under it. They admitted suppressors are in common use, with 2.6 million registered units. They conceded that the $200 tax stamp functions as a financial barrier that prices poor Americans out of exercising their rights. They acknowledged that 9 to 12-month waiting periods, with no maximum time limit and no recourse if the government simply never processes your application, constitutes a de facto ban. These aren't concessions you make because you're being generous. These are admissions you make because continuing to argue otherwise would result in a Supreme Court opinion that guts your position even worse. This was a strategic retreat. But here's what makes it calculated and cynical. The DOJ specifically stated this confession applies only to suppressors and should not be read as abandoning their defense of machine gun bans, short-barreled rifle restrictions, or destructive device regulations. They're trying to sacrifice the most sympathetic category of the National Firearms Act to save the rest of it. They're hoping courts will take this confession, rule narrowly, and leave everything else intact, except the Ninth Circuit Court of Appeals refused to play along. The 3-judge panel that decided United States versus Patterson didn't just accept the government's confession and move on. They wrote an 89-page unanimous opinion that systematically demolishes the constitutional foundation of not just suppressor regulations, but the entire framework of NFA taxation, registration, and prior restraint. And the implications are seismic. So who is Michael Patterson and how did we get here? He's not a constitutional crusader, he's not a professional plaintiff, he's a competitive shooting instructor running a firearms training academy in Scottsdale, Arizona, teaching law enforcement and civilians. 15 years of instruction left him with permanent hearing damage. In March 2024, he bought a silencer Comer Omega 9K suppressor for $650 specifically to protect what hearing he has left. That's it. A guy trying to protect his ears while doing his job, but to exercise that right, the federal government demanded he pay a $200 tax, submit fingerprints, provide photographs, get passport-style photos taken, notify his county sheriff, fill out ATF Form 4, and then wait. Patterson did everything the government demanded. He followed every requirement. His application sat in the ATF's National Firearms Act Division for 11 months and 17 days. Almost a year. For a background check that takes 15 minutes when you buy a handgun, the Firearms Policy Coalition approached him about challenging not just the waiting period, but the entire constitutional basis for the NFA suppressor framework. Patterson agreed on one condition. The case had to seek relief for all suppressor owners, not just him. That tells you something about the man. He could have pursued narrow individual relief and gotten his suppressor faster. Instead, he committed to years of litigation to fix a broken system for everyone. The complaint filed in the District of Arizona didn't ask for incremental reforms or minor tweaks. It challenged the whole structure: the tax, the registration, the waiting period, the prior restraint on a constitutional right. District Court Judge Sarah Henderson issued a 73-page opinion in September 2024, finding that suppressors clearly meet constitutional protection under the Supreme Court's Bruen standard. That should have been the end of it. But the DOJ immediately appealed to the Ninth Circuit Court of Appeals, which has a well-earned reputation as the most hostile venue for Second Amendment cases in the country. And this is where everyone expected Patterson to lose everything. The Ninth Circuit isn't just unfriendly to gun rights, it's aggressively, systematically, almost reflexively hostile. Before this decision, the circuit had ruled against Second Amendment claims in 23 consecutive cases since Bruen came down in June 2022. They upheld California's assault weapon ban, magazine capacity limits, ammunition background check requirements, even a ban on firearm advertising visible from public streets. The three-judge panel assignment made it worse. Judge Paul Watford had previously written opinions upholding California's 10-day waiting period for all gun purchases, even for people who already own firearms. Judge Andrew Hurwitz authored the decision upholding Hawaii's ban on openly carrying firearms in public. Judge Jacqueline Nguyen had never voted to strike down a single gun regulation in her entire judicial career. Not one. Gun rights organizations knew they were walking into an ambush. The Second Amendment Foundation allocated $280,000 for the appeal, anticipating they'd lose at the circuit level and need resources for a Supreme Court petition. The Firearms Policy Coalition war-gamed scenarios, where the Ninth Circuit wouldn't just uphold the NFA provisions, but issue an opinion so hostile to gun rights it would actually make things worse by creating bad precedent other circuits could cite. Oral argument was scheduled for January 28, 2026. Everyone expected a disaster. Then the government filed its confession of error on January 20th. Oral argument never happened. And instead of the expected loss, Patterson won everything, a unanimous opinion from the Ninth Circuit, striking down core provisions of the National Firearms Act. If you understand how rare that is, you understand why this decision is a constitutional earthquake. Now we need to talk about why the DOJ couldn't defend this anymore, because it comes down to a Supreme Court decision that fundamentally changed how courts analyze gun regulations. In 2022, the Supreme Court decided New York State Rifle and Pistol Association versus Bruen. That case involved New York's requirement that you show proper cause to get a concealed carry permit, giving government officials discretion to decide whose reasons were good enough. The Supreme Court struck it down and, more importantly, established a new constitutional test that applies to all gun regulations going forward. Before Bruen, courts used a two-step framework. First, does the Second Amendment even apply to this? Second, if it does the regulation survive means-end scrutiny, where courts balance the government's interest in public safety against the individual's right to bear arms? That balancing test let courts uphold almost anything if they decided the government's safety interest was compelling enough. Bruen eliminated balancing entirely. Justice Clarence Thomas wrote for the majority that the Second Amendment is not a second-class right subject to interest balancing. You don't get to balance away constitutional rights because you think the policy outcome would be better. Instead, courts now apply a text, history, and tradition test. First, does the Second Amendment's plain text cover the regulated conduct? If yes, the burden shifts entirely to the government to prove the regulation is consistent with the nation's historical tradition of firearm regulation from the founding era. Not from 1934, not from the progressive era, from when the Second Amendment was ratified. This creates an impossible problem for suppressor regulations, and the DOJ knew it. Suppressors weren't invented until 1902, when Hiram Percy Maxim patented the first commercially successful design. There literally cannot be any regulation of suppressors from 1791 because they didn't exist yet. The government tried to argue that historical regulations of other dangerous items, like gunpowder storage laws, could serve as analogs. But Bruen requires that the historical regulation be relevantly similar in how it burdens the right and why. A colonial-era law about storing kegs of gunpowder in warehouses because of fire risk has nothing to do with a $200 tax on a hearing protection device in 2026. The DOJ's own Office of Legal Counsel spent 7 months searching for historical analogs that could justify suppressor registration and taxation. They found nothing that survived scrutiny. There is no founding-era parallel to taxing a constitutional right at 800% of the item's value. There's no historical tradition of making people wait a year to exercise a right after they've already passed a background check. And that's why the government had to confess error rather than defend the indefensible in front of a Supreme Court that's already told them the framework doesn't work. But confessing error and hoping for a narrow ruling didn't work, because Chief Judge Jacqueline Nguyen wrote an opinion that doesn't just accept the confession. It builds a constitutional framework that threatens everything the NFA does. The opinion rests on 3 independent pillars, and this is critical. Each one, by itself, is sufficient to strike down the suppressor provisions. You don't need all 3. Any one of them wins the case. Pillar 1 addresses the common use requirement from District of Columbia versus Heller, the 2008 case that recognized an individual right to bear arms. The government argued that 2.6 million suppressors sounds like a lot in absolute numbers, but represents only about 2% of gun owners, making them statistically unusual. Judge Nguyen demolished this argument by pointing out that when Heller was decided in 2008, there were approximately 1.5 million AR-15 rifles in civilian hands. Yet the court specifically cited AR-15s as protected arms in common use. If 1.5 million AR-15s met the threshold in 2008, then 2.6 million suppressors exceed it in 2026. The government can't move the goalposts based on what percentage of owners have adopted something. Pillar 2 tackles the tax as a prior restraint on constitutional rights. The court found that $200 in 1934, when the NFA was enacted, is equivalent to $4,600 today when adjusted for inflation. The average suppressor costs $600. That means the tax is 8 times the value of the item being taxed. No other constitutional right can be taxed at 800% of its exercise cost. You don't pay $400 to register to vote. You don't pay 8 times the cost of a printing press to publish a newspaper. The court held that even if some modest tax might be permissible to cover administrative costs, a tax designed to be prohibitively expensive is a prior restraint that violates the Constitution. Pillar 3 addresses the waiting period, and this one has implications far beyond suppressors. The court found that a 9 to 12-month delay in exercising a constitutional right, with no maximum time limit and no recourse if the government simply never processes your application, constitutes a de facto ban. Patterson waited 11 months for approval after already passing the same background check that takes 15 minutes for a handgun. There's no public safety justification for that. It's administrative dysfunction being used as a barrier to rights. If the government can make you wait a year, they can make you wait forever. And the court said that's unconstitutional, but Judge Nguyen didn't just strike down the law and walk away. The opinion includes a detailed 90-day implementation timeline that phases out NFA suppressor requirements while maintaining background checks through the existing NICS system, the same instant background check used for all firearms purchases. This is critical because it prevents the parade of horribles the government always warns about when gun regulations get struck down. Effective immediately as of January 23, 2026, the ATF must stop collecting $200 tax stamps for new suppressor purchases. Anyone buying a suppressor after this date pays only for the suppressor itself and undergoes a standard NICS background check, identical to purchasing a handgun. No fingerprints, no photographs, no ATF Form 4, no Chief Law Enforcement Officer notification. No waiting period beyond the instant background check processing time, which typically takes minutes. For the 347,000 people currently waiting on pending Form 4 applications submitted before January 23rd, the ATF has 14 days from the decision to auto-approve all applications pending a successful NICS recheck. Just run the background check again to make sure nothing's changed and approve it. Within 90 days, the ATF must refund all $200 tax stamp payments for applications submitted after January 1, 2024. That's approximately $69.4 million in refunds. Most significantly, the court ordered that all persons currently in lawful possession of any firearm are deemed lawful possessors of suppressors without registration. Read that again. If you legally own guns now, you can legally own suppressors now. The NFA registry for suppressors becomes obsolete. You don't need to be on a list. You don't need permission. You exercise your Second Amendment right the same way you do for any other firearm. Now, if you think this story ends with suppressors, you haven't been paying attention. Make sure you're subscribed because what happens next is going to move fast, and the legal dominoes are already falling. The opinion's reasoning doesn't stop at suppressors, and the court knew exactly what they were doing. Judge Nguyen included a 20-page section of what lawyers call dicta, statements not strictly necessary to decide the case, but providing guidance for future litigation that systematically applies the same Bruen analysis to short-barreled rifles and shotguns. The implications are devastating for what remains of the NFA. Short-barreled rifles, defined as rifles with barrels under 16 inches, have been NFA items since 1934. The government's historical justification has always been that SBRs are concealable and therefore more dangerous than full-length rifles. But the opinion points out that millions of Americans legally carry concealed handguns in all 50 states after Bruen struck down May issue permitting schemes. If concealability justified banning short-barreled rifles, it would justify banning handguns. But the Supreme Court already held in Heller that handguns are protected arms. The opinion cites data showing approximately 4.2 million AR-15 pistols and braced firearms in civilian hands, all with barrels under 16 inches. These are already in common use for lawful purposes, including home defense. Judge Nguyen wrote that she could find no principled distinction between an AR-15 pistol with a 13-inch barrel and an AR-15 rifle with a 13-inch barrel, except that one requires a $200 tax and federal registration, and one doesn't. That's not a constitutional distinction, that's arbitrary line drawing. 3 separate lawsuits challenging short-barreled rifle provisions were filed within 18 hours of the Patterson decision, all in the Ninth Circuit, specifically to take advantage of binding precedent. Legal experts are giving these cases a 95% probability of success because the government already admitted in Patterson they can't defend arbitrary barrel length restrictions under Bruen. If the same constitutional test applies, and it does, the outcome is foreordained. But there's a complication nobody's talking about loudly enough. This is a federal court decision striking down federal law. 8 states have their own suppressor bans written into state criminal codes that exist independently of the NFA. If you live in California, New York, New Jersey, Illinois, Massachusetts, Rhode Island, Delaware, or Hawaii, you're still violating state law if you possess a suppressor, even though federal law no longer prohibits it. California Penal Code Section 3-3410 makes it a felony to possess a silencer, with penalties up to 3 years in state prison. New York Penal Law 265.10 classifies suppressors as dangerous weapons with mandatory minimum sentences. These state laws were written to mirror federal NFA restrictions, but they remain on the books as independent criminal statutes. However, the legal pathway is clear, and it's faster than most people realize. The 14th Amendment incorporates the Second Amendment against the states, meaning state governments are bound by the same constitutional limitations as the federal government. If the federal NFA suppressor provisions violate the Second Amendment under Bruen, then identical state provisions also violate the Second Amendment under the same analysis. California already has a pending suppressor ban challenge that was stayed, waiting for developments in federal NFA litigation. That stay gets lifted now. The case moves forward with Patterson as binding precedent in the Ninth Circuit, which includes California. Gun rights attorneys estimate that state suppressor bans in at least 5 of the 8 states will fall within 12 months. The same constitutional analysis, the same result. And state legislatures will face a choice: repeal the laws proactively or wait for courts to strike them down and potentially award attorneys' fees to the plaintiffs. And now we get to the question everyone's asking, the one the DOJ was terrified of. Does this decision open the door to challenging the machine gun ban? The answer is complicated, but yes. Challenges are already being drafted. The 1986 Firearm Owners Protection Act included the Hughes Amendment, which prohibits civilian possession of machine guns manufactured after May 19, 1986. This created a closed registry where only approximately 630,000 transferable machine guns exist, driving prices to $15,000 to $40,000 for weapons that cost $600 to manufacture. It's artificial scarcity created by law. The constitutional analysis for machine guns is harder than suppressors because of United States v. Miller from 1939, which stated that the Second Amendment protects weapons with some reasonable relationship to militia use. Machine guns are clearly militia weapons. They're standard issue for every military force on Earth. The M4 carbine, the M249 light machine gun, these are militia arms by any definition. But Miller also referenced weapons in common use, and the Hughes Amendment has artificially prevented machine guns from being in common use by freezing the supply for 40 years. Here's where Patterson creates an opening that's going to be exploited. The opinion specifically states that the government cannot argue something is unusual when the government's own regulations prevented it from becoming common. That exact reasoning applies to machine guns. Before 1986, machine gun registrations were growing at 15,000 to 20,000 per year. If that growth had continued at even a conservative rate, there would be over 1.2 million registered machine guns in civilian hands today, easily meeting any common use threshold. The government created the scarcity, then argues the scarcity justifies the ban. That's circular reasoning, and Patterson rejects it. Second, Patterson holds that registration and taxation requirements that function as prior restraints are unconstitutional. The Hughes Amendment doesn't just tax or register machine guns, it bans them entirely for civilians. If a $200 tax and registration requirement violates the Second Amendment, an absolute ban certainly does. The Firearms Policy Coalition has confirmed they're preparing a Hughes Amendment challenge to be filed in the Fifth Circuit, the most gun-friendly appellate court in the country. They're recruiting plaintiffs who are FFL manufacturers currently allowed to possess post-1986 machine guns as dealer samples, people who can demonstrate concrete harm from the ban. This is the ultimate constitutional question, and it's coming whether lawmakers like it or not. Does a 40-year-old ban on an entire category of arms survive constitutional scrutiny after Patterson, after Bruen, after the Supreme Court has told us the Second Amendment is not a second-class right? Or is the National Firearms Act, as a comprehensive regulatory scheme, finished? The answer will define firearms law for the next generation, and it's going to be decided in courtrooms over the next 2 to 3 years. The legal framework is collapsing in real time. Most gun owners have no idea this is even happening because it's not getting the coverage it deserves. If you want to stay ahead of every major development in firearms law, constitutional litigation, and the cases that will reshape American rights, you need to subscribe to this channel right now and turn on notifications. Hit that like button, share this video with every gun owner, everyone who cares about constitutional rights, everyone who wants to understand how the legal system actually works when it's forced to confront its own failures. The next 12 months will be historic, the dominoes are falling, and we're going to cover every single one. I'll see you in the next one.